The month of June is always a big month for the Supreme Court of the United States, and this term is no exception. In fact, this term involves bigger constitutional cases than in many other years, including cases involving the Second Amendment's right to keep and bear arms, ATF authority, regulatory authority by the deep state over your lives, Donald Trump and presidential immunity, and more and more. I'm going to give you the top 12 cases that still need to be decided, and we're going to talk exactly about what I think is going to happen and why they matter to your freedoms here in this great country of the United States. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and best-selling author. I'm happy to report, already hit some bestsellers list on Amazon. Best-selling author of the new book, Israel Disarmed: What the 10/7 attacks by Hamas teach Americans about the right to bear arms. Check out the book. It's a little shorter than my other books, but it's very important. And it teaches how the Israelis were not supposed to forget basic lessons of what happened in World War II, i.e. don't get disarmed. Make sure you're prepared. And there were mistakes made by the Israeli government and the Israelis by not adopting the right to keep and bear arms robustly, and the consequences of that, and how they're trying to come back to adopt a version of the Second Amendment over there, not as robust as ours, but they're making progress. Very important lessons that we all need to keep in mind here in the United States, because we always want to learn from the mistakes of other people, because those are the most expensive mistakes, the ones that you make yourself. So better to learn from the mistakes the Israelis made in not adopting the right to keep and bear arms and not having armed citizens as robustly as we have in the United States, and why we must never lose our Second Amendment rights, because otherwise bad things can happen to us like we saw, unfortunately, on October 7th. I'll do more videos about that in the future, but make sure you check out on Amazon, Israel Disarmed, my 8th book. All right, folks, here we go. Top 12 cases. I would do a top 10 list, but I really think there's 12 cases I want you to keep your eye on, one of which dealing with the NRA, of course, has been decided, but I'm going to include that on the list because it's a big deal. And I'm going to go down the list of what I consider to be the top 12 cases that are going to be decided between now and the end of June, which will be the end of the 2023-2024 Supreme Court term. And I think this is my order of import in constitutional law, even though, of course, to me, there's really nothing more important than the Second Amendment. But remember, the Second Amendment is only one right. It's only one component of the Constitution that preserves our freedom. It's a very important right, but of course, other rights are important too, including the structure of the Constitution that makes sure that our freedoms are protected, not just by virtue of the Bill of Rights, but also by the structure of the Constitution, such as separation of powers and federalism, and on and on. So let's go through the list of cases that you need to know about and what's going to happen in my view, and that way you'll be the smartest person in the room for the next month. The first case, of course, we all need to be cheering about is the relentless case dealing with the federal government and whether or not the United States Supreme Court is going to overrule and throw in the trash bin of history the notorious Chevron Doctrine. Now, when you hear the phrase Chevron Doctrine, you run for the hills, because what the Chevron Doctrine basically says that when in doubt, the administrative agency, the deep state agency, gets to decide how to interpret its enabling regulations and how to best interpret the regulations it promulgates. So basically, it is a huge, huge thumb, if not foot or brick, on the scale of justice when you, an American citizen, are litigating against administrative agencies and the deep state. Because if you're in a fight, whether it be in a letter writing campaign, an administrative hearing, or a lawsuit or a criminal case against the federal government, involving the meaning or interpretation of a federal regulation, the Chevron Doctrine, by and large, allows the government's regulatory body, to sort of say what the regulation means or how the regulation should be interpreted. And if there's any dispute under the Chevron Doctrine, the presumption is that the governmental regulatory agency wins the interpretive battle. And the Chevron Doctrine basically gives that extra authority and power to bureaucrats. Now, if you get rid of the Chevron Doctrine, this eliminates the ability of the ATF, when they write nasty letters to FFLs and to other Americans, to be able to say, and our interpretation is right because the Chevron doctrine says we get to decide. The deference is to us, the government, and not to you, the servant. I mean, citizen, right? No, if you get rid of the Chevron doctrine, you're taking away a massive amount of leverage that the deep state government has against American citizens. And my prediction, and you guys can keep track of this and see if I'm right at the end of the day, is that the Chevron doctrine will indeed be overruled. It will go in the trash bin of history, and that will be a very good thing. So watch carefully the case of Relentless, the most important case, in my view, to be decided in the next several weeks. I think the second biggest case that you need to watch out for is, of course, the Donald Trump presidential immunity question. Because this sort of situation really has not come up in a real way before, the question of presidential immunity, i.e., what immunity, if any, does the commander-in-chief, the executive, under Article 2 of the Constitution, what immunity does he or she have from being indicted and charged with crimes for what they did while they were president? Now, historically, there's been a robust view that you have broad presidential immunity because you can't have the commander-in-chief being sued and or indicted in every one of the adverse political counties in the United States for something he has done while he was president. So if Barack Obama issues a drone strike, you don't want him being indicted all across the country in certain places because people don't like Barack Obama. Likewise, you simply don't want this. So historically, the presidential immunity has been interpreted very broadly for acts done while he was president. Now here, Donald Trump has been alleged by the special prosecutor Jack Smith, who's been hired by the Department of Justice to go after Trump. He has been indicted in the District of Columbia for various alleged crimes associated with the January 6th situation, the protests and the crimes that were committed on that date in Washington, D.C. Donald Trump has been indicted as part of that, and also part of saying that he tried to overthrow an election. This kind of stuff is also why he was indicted. But of course, at the same time, he is a candidate for the presidency. He is the president. He was the president in and around January 6th through January 20th and so on of 2021. So he has a duty to ensure that federal laws are enforced. He is being the head of the executive branch. That means he oversees like the Department of Justice and all these agencies. And there's very little doubt that he has an obligation and an authority to ensure that the Constitution is respected, as well as to ensure that federal election law is complied with. And arguably, that's what he was doing. So that is a big thing to see what the court does there. So what I think is going to happen is this. The Supreme Court is going to reverse the D.C. Court of Appeals decision that said Donald Trump could be indicted and charged with crimes for actions he engaged in while he was president. They're going to reverse that, and they're going to say that that is simply too broad of a decision by that anti-Trump court in the District of Columbia. But they are going to go on to say that there are certain scenarios where a president could be indicted and charged with a crime after he leaves the White House for things he does while he is president. And I think they're going to draw a line that basically says that if the president himself commits something like a robbery or a murder or something along those lines in his personal capacity to undeniably advance some personal goal and not any kind of a policy goal or any kind of legal goal or legal obligation, I think there'll be some sort of test that the Supreme Court sets out in the Trump immunity case, and we'll send the case back down to the lower courts to say, apply this new test we've developed and let us know how much of the allegations brought by Jack Smith against Donald Trump are immune under the new standard or not immune under the new standard to be articulated by the Supreme Court in the Trump case. That is what's going to happen. But the D.C. Court of Appeals will be reversed. He will be found to have some level of immunity, and the scope of it will have to be determined on remand. That is my prediction. You can hold me to it if I get it wrong, and you'll let me know. But that's what I think is going to happen in the Trump presidential immunity case, the second most important case we're going to hear about in the next few weeks. The third case you need to know about is the NetChoice case versus Ken Paxton down there in Texas. The question of NetChoice is whether restrictions on social media companies are constitutional. It's my best guess that the Supreme Court is going to rule that restrictions are unconstitutional. So I think that that is going to be a First Amendment decision. It's going to be in favor of the social media companies against the government. And, one can have a debate about the role of social media companies and all that, but we certainly don't want the government interfering with these social media companies. On the other hand, you and I know that a lot of these social media companies do lean heavily to the left. I do think that Elon Musk's X platform does not lean to the left. I think that's the exception. So I am aware of that. But bottom line, I think the court's going to be like, hey, the government really can't be getting involved in regulating a lot of this content moderation. And I think they're going to say, as a general matter, the court's going to say that government cannot get involved with this. And I think that's going to be the outcome in the NetChoice case. Of course, the fourth big case here is the United States versus Rahimi case, which we've talked a lot about. Now, we've talked about what's going to happen here under 18 U.S.C. 922 G8, federal gun control law. That section says that if you are subject to a domestic violence restraining order, you're not allowed to possess a gun during that time. The Fifth Circuit Court of Appeals held that the statute, meaning 922 G8, is facially, very important word I'm about to use, facially unconstitutional. And the U.S. Supreme Court, I think, is going to reverse that, and they're going to say, look, we are not in a position to say that 18 U.S.C. 922 G8 on its face, in all circumstances, forever, is always and every time unconstitutional under the Second Amendment. The court's going to say, in my view, this is my prediction, they're going to say we're going to reverse the Fifth Circuit decision, and we're going to say that there are instances where if a person is found to be a violent danger, not a metaphorical danger, a violent danger to himself, i.e. a suicide risk, or a violent danger to others because he's either a psychopath or he's a violent thug, any of those scenarios, I think the court is going to say that he can be disarmed. And again, I think what's going to happen, Rahimi, is if you're a violent danger, you're going to be disarmed. That's what they're going to say. And it's a question of fact after due process in a full-blown hearing or a trial. That's where I think the court's going to go here. And then again, ultimately down the road, I think if you're a non-violent felon with no history of violence, then I think you're going to get your Second Amendment rights. I think that the Third Circuit decision in a range will become the U.S. Supreme Court decision in due course, although that won't happen immediately. I think in the short run, Rahimi will get reversed. Supreme Court will distinguish and say, there's a question of fact as to whether or not Mr. Rahimi is a violent danger, physical violent danger, and I think that's where going to come out on this. So they will reverse the Fifth Circuit, but I don't think the decision will be terrible for the Second Amendment, but only time will tell. Now, the next decision is the fifth decision we need to watch out for is the Moyle decision. This case involves really a question of federal preemption, whether Medicare laws governing emergency care physicians, emergency room doctors, and medical professionals, whether or not that restriction somehow overrides an Idaho state law restricting abortion procedures in certain instances. It's a fight out of Idaho in federal court as to whether or not the federal Medicare statute trumps state abortion restrictions. The Supreme Court, I think, is going to conclude that the federal law does not preempt the state abortion restrictions. That will be the decision in Moyle. The sixth most important decision that's going to come out of the Supreme Court is the Fisher versus United States case. This is a critical case involving the January 6th protesters. It also involves the longest potential prison sentence that Donald Trump faces involving the Jack Smith prosecution of him in D.C. The Fisher case is whether or not the Jack Smith and the Department of Justice has been abusing the federal law by applying a law that arose from the Enron financial scandal, and the law basically saying that you cannot obstruct corruptly official proceedings, which everyone always understood that to be. You cannot tamper with witnesses or destroy documents if you're involved in some sort of a federal or state case, a civil lawsuit or a criminal case. You can't destroy documents or tamper with witnesses. The government is trying to argue that protesting, delaying the counting of the electoral votes on January 6th violated this law. The reason why the Department of Justice under Merrick Garland and Jack Smith really like the statute is because there's a potential, I think, 20-year prison sentence. So a lot of January 6th protesters have rolled over because they could not afford to risk such a long prison sentence. But I'm happy to report, I believe the U.S. Supreme Court is going to slap DOJ down and basically spank them and tell them that the interpretation of that federal law in Fisher by the Department of Justice is simply stupid and wrong, and they're going to be bye-bye, you can't use it, which is going to take a major bit of leverage DOJ has against Donald Trump and the January 6th protesters away from the government. That will be a big win. Of course, the next thing, the number 7 case here, is the NRA case involving Vulu. And we have, the Second Amendment, or the NRA has won this case. As you know, this is a First Amendment violation where the state of New York essentially engaged in content-focused viewpoint discrimination against the NRA's pro-Second Amendment, pro-gun rights position in terms of how they went about threatening, allegedly, financial and other business partners of the NRA to not do business with them, and this was allegedly a violation of the First Amendment. The NRA won this case. The court did say that a claim was stated, and now that case will be remanded for further consideration. The number 8 case is the Rahimi case. This involves a challenge to this SEC. The reason why this is so important is this involves when administrative agencies like the FCC, like the FDA, like potentially the ATF, like the SEC, whether or not they can do all sorts of terrible things to you as an American citizen, including fining you for damages and punishing you financially without a jury trial, meaning can an administrative law judge, an ALJ, simply do all sorts of bad things to you, the American citizen, financially, where you have a prosecutor is like the Security and Exchange Commission, and the judge works for the Security and Exchange Commission, or the prosecutor works for ATF, and the judge works for ATF, and they're deciding what happens to you, or whether or not this system that the government has devised violates the United States Constitution's the 7th Amendment, which gives you a right to a jury trial in certain civil matters. And I think in this case, it will be viewed as, yes, indeed, the 7th Amendment can be violated on certain occasions where you're trying to punish somebody financially in a fight with the federal government. The 9th case is the Alliance for Hippocratic Medicine. This is going to be an easy case. This involves essentially the fight over Mifepristone, which is the abortion pill, the abortion drug. And basically, I think the Alliance versus Hippocratic Medicine is going to be an easy ruling for the U.S. Supreme Court. I think they're going to say that the plaintiffs that challenged the regulations involving allowing Mifepristone to be prescribed telephonically and telemedicine call versus face-to-face, I think they're going to just say that the plaintiff in this case lacks standing. And they're going to say because they lack standing, they're going to toss the case out on standing grounds because Article 3 of the U.S. Constitution says that federal courts only have authority to hear cases or controversies. And because the plaintiff lacks standing, there's not a real case or controversy here in the Alliance versus Hippocratic Medicine case involving the abortion pill Mifepristone. That is, I think, what's going to come down here. We'll see very soon. The next case, of course, is a big one, the bump stock case involving Michael Cargill's challenge to the bump stock regulation. This was, yes, during the Trump administration. I'm not denying that. But again, we've talked about why strategically that made sense because it stopped Congress from doing stupid things with the definition of machine gun, which would have been very bad for the Second Amendment by bringing a certain semi-automatic firearms within the definition of machine gun. We'll do a whole video about that separately. But for now, the Cargill case is a big deal. And hopefully the Supreme Court says that the ATF exceeded its authority by banning bump stocks without going to Congress first. That's what we're looking for in the Cargill case. The 11th case on this list is Murthy versus Missouri, or Missouri, depending on what part of Missouri or Missouri you're from. This involves whether certain actions of social media companies constitute state actions or government actions due to government pressure. In other words, the issue is the government goes to a social media company and says, you must do this, or we want you to do this. And because we want you to do this, and the social media company then does it, does the actions of the social media company at that point be a state case or state action or governmental action where they can be sued? And again, I think this is another one of these cases where I think the Supreme Court's going to kick this case on standing. I don't think they're going to get to the merits in this case. I think they're going to say that the plaintiffs don't have standing in the Murthy versus Missouri case, but we shall see. And the last case, the number 12 case that you should be aware of, is the City of Grants Pass. The City of Grants Pass versus Johnson. This is a very interesting Eighth Amendment case. As you know, the Eighth Amendment deals with cruel and unusual punishments, not just for the death penalty, but in other contexts. And the issue here is whether or not applying generally applicable camping rules as to where you can camp outdoors and where you cannot camp outdoors, applying them to homeless people, to homeless camps, whether or not this constitutes an Eighth Amendment violation by kicking them out of their homes on the streets. And I think the Supreme Court is pretty clearly going to answer that there is not a constitutional violation for states and cities to clean up homeless encampments or to move homeless encampments or to kick homeless people off the streets and not allow them to camp there simply by citing to basic camping restrictions to say you can camp in the woods over here, but you cannot camp in Times Square in New York City or whatnot. All right, so there you have it, the top 12 cases you need to be on the lookout for between now and June, with the exception of the NRA case, which of course was already decided. So there you have it. We'll be covering these as they break because they all involve our rights. And remember, the Second Amendment is very important, but it's not the only right we must preserve. They all work together. Every right is important, and we must preserve them all, and we must preserve the Constitution itself, because if we don't do this, I can assure you the other side will go full totalitarian and tyrannical on us, and we will have no rights, and we will be, who knows what we'll be doing, but I'm sure it won't be anything that any of us wants. So let's hope that the Supreme Court continues to stand up for the Constitution, not just for the Second Amendment, but for all of our rights and the document and the rights found within that document itself. So there you have it. All right, folks, hope you learned something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner. Subscribe and resubscribe. Don't get kicked off this channel. And of course, don't forget to check out my book on Amazon, Israel Disarmed, What the 10/7 Attacks Can Teach Americans About the Right to Bear Arms. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.